There may be a new twist to the crisis in the All Progressives Congress in Rivers State as the Court of Appeal today granted the prayer of the faction of the party for a stay of execution on the judgment of January 7th that nullified all the primaries of the party and restrained INEC from fielding the party's candidates in the elections in Rivers State. This, however, has left the council on different parts as to the limits of the ruling. Our correspondent Emmanuel Ray reports.
Security around the Court of Appeal premises in Port Harcourt, Rivers State, was quite visible from early in the day, as 5 appeals penned before Justice Ali Gumel-led 3-man panel. All cases bordering under Justice Kolawole Omotosho's judgment of January the 7th. The courtroom is a full house, as the ruling of a stay of execution is delivered by the panel. All 3 justices agree that due to the multiplicity of the appeals before them, it suggests that all parties are dissatisfied with the judgment, ordering that a stay of execution is just and granted. It is good news to some.
By this ruling today, all Progressive Congress, the APC in Rivers State, and their candidates are free to participate in the election. They can go about their campaigns and go about everything that's lawful to be done to ensure that they are on the ballot.
But not so good for others.
INEC, like the court observed, did not file anything, any process to refute that they did not publish the names. They didn't file anything. And in law, the moment you don't find anything to rebuke what has been said, that is accepted as veracious.
As some are seen talking in small groups, suggesting that the issues may be far from being resolved. This ruling, in the eyes of many, is already throwing up talking points, especially as more appeals pen before the Justice Ali Gumel-led panel of the Court of Appeal. And many think it may have far-reaching implications on the electoral body as well as the over 60 political parties participating in the elections in the state. Emmanuel Irei, Channels Television News.
The Code of Conduct Tribunal has adjourned the trial of Justice Walter Onoye to February the 13th, following an application by the Defense Counsel, Mr. Adeboyega Awomolo San. At the resumed trial, Mr. Adeboyega informed the tribunal of the petition submitted to the National Judicial Council by the Attorney General of the Federation, seeking the investigation of the suspended Chief Justice of Nigeria over allegations of alleged non-declaration of assets. The prosecution team, led by Mr. Aliu Umar, did not oppose the application, and after they mutually agreed on adjournment, the chairman of the tribunal, Mr. Danladi Umar, adjourned the trial to the 13th of February with an order mandating Justice Onoye to appear at the next proceedings.
The tribunal was half-filled as the trial of the suspended Chief Justice of Nigeria, Walter Onoye, continues in Abuja. On the arrival of members of the Code of Conduct Tribunal, lawyer to Justice Onoye informs the tribunal that the Attorney General of the Federation has submitted a petition to the National Judicial Council requesting the investigation of the suspended Chief Justice of Nigeria. He argues that the continuation of Justice Onoye's trial will amount to double jeopardy. This application was not opposed by the prosecution, but the insistence of the chairman of the tribunal disregarding the application leads to a heated argument between the defense lawyers and the chairman of the tribunal. To calm frayed nerves, the prosecutor calls for a 30-minute adjournment, and after resuming proceedings, the chairman of the tribunal granted the application for adjournment, with a condition that Justice Onoye should appear before the tribunal at the next date to take his plea. With the adjournment granted, the defense lawyer debunks claims of a soft landing for the embattled CGN.
We are in a place where law regulates and guides all human affairs. We are here because the law says we should come here. So I don't know if you'll stop landing. Maybe you are negotiating it.
The prosecutor explains the reason behind the adjournment.
The defense had approached me and asked me to cooperate with them for an adjournment to Thursday next week. And I conceded to them because every person, whether the defense or the prosecution, is entitled to 5 adjournments during a criminal trial. But I think what spoils the matter was when he now applied and gave the reason that is because the NJSC is seized of the matter. The Code of Conduct Tribunal is not subject to the jurisdiction of the NJC.
Justice Walter Onogen, who is currently under suspension for alleged non-declaration of assets, is expected to be arraigned on the 13th of February 2019.
Staying with legal matters, the appeal court has adjourned the hearing of an appeal filed by Justice Walter Onogen challenging his suspension till February the 12th, 2019. The case was adjourned on the request of his lawyer, who wanted the appeal heard together with 2 other appeals that he said were related to the trial at the CCT. Onogen had appealed the ruling of the Code of Conduct Tribunal ordering his suspension. He pleaded that the chairman of the CCT and a member, Mrs. Julie Anabor, had erred in law and violated the Constitution when they ordered his suspension. He also claimed that they violated his right to a fair hearing.
The appeal filed by the Chief Justice of Nigeria, Honorable Justice Onogen, came up for hearing today. And actually there are 3 appeals, 2 other appeals which ought to have been listed before the Court of Appeal today, but only 1 was listed. Therefore, we needed the 3 appeals to be taken together so that we will not waste precious judicial time, because this is a matter of utmost national urgency. And fortunately, the court agreed with us, and this appeal, together with the other 2, were all adjourned to February 12th, 2019. So on that day, we'll come and take the appeals together.
A former Minister of State for Defense, Senator Musliu Banikoro, had told the Federal High Court in Lagos that there is no receipt to show proof of the 1.2 billion naira and the sum of $5 million, which he delivered to his friend, former Ekiti State Governor Ayodele Fayose. Senator Banikoro had, in his statement while testifying at the 5th prosecution witness before Justice Mojisola Olatoregun, in the case against Fayose and Spotless Limited, a company believed to be owned by the former governor. The former senator also said that he did not sign for the money when he received it from the former National Security Advisor, the NSA, Colonel Sambo Dasuki, retired, for onward transfer to Mr. Fayose. Obanikoro added that the NSA never asked him at any time to render an account, even as he admitted that he had returned to the federal government 200 million naira out of the money he received from Dasuki. According to the former senator, the money was allegedly given for the purpose of securing Lagos and in furtherance of the governorship bid of Mr. Fayose. During his testimony, the witness got emotional and admitted that it was painful and tough for him to testify against his friend and former ally. Mr. Fayose is on trial for allegedly receiving and keeping 1.2 billion naira and $5 million allegedly stolen from the Office of the National Security Advisor, the NSA, contrary to the Money Laundering Act. He had pleaded not guilty, though, when he was arraigned on an 11-count charge last October the 22nd. Obanikoro is listed as one of 22 witnesses that will testify in the trial, which continues tomorrow. More stories now. A federal high court sitting in Lagos has struck out a fundamental rights enforcement suit filed by alleged kidnapper Chukwudumeme Nwamadike, popularly known as Evans. Evans had filed a suit against the police over the seizure of his property. Justice Mojisola Olatoregun, however, held that the court lacked the jurisdiction to entertain the case, as the proper venue to ventilate the suit ought to have been the Lagos State High Court, where the applicant was already facing charges of kidnapping. The judge also noted that the respondent did not file any defense despite being served hearing notices. She held that when confronted with the claims under the Fundamental Rights Enforcement Procedure, it will be important for the court to critically look at the release sought in this case. According to her, the main issue to be decided is whether the plaintiff's claim constitutes a violation of his human rights under the Fundamental Human Rights Enforcement Procedure adding that the right to own property cannot be denied except for due process of the law. She therefore held that the applicant failed to show that within the circumstances of his arrest, the property were forcefully seized. In June 2018, Evans thought, through his lawyer, Mr. Olukoya, filed the suit asking the court to declare that the alleged forceful seizure of his property by the respondents without any cause of order was illegal and unconstitutional. President Muhammadu Buhari has sworn in the chairman and members of the Independent Corrupt Practices and Other Related Offences Commission, ICPC, with a charge to assist government in cleaning the nation's public sector. He observes that despite his administration's anti-corruption drive, some agencies of government still divert or refuse to fully account for revenues generated. The president also received some retired generals who pledged to support his re-election bid. Correspondent Ibrahim Adra now reports.
It was a brief ceremony with President Muhammadu Buhari presiding. First to take the oath of office and allegiance is the chairman of the Independent Corrupt Practices and Other Related Offences Commission. 8 members also swore and took turns to have a handshake with the president, including a 27-year-old who is representing the youths. President Buhari charged the ICPC management to assist government in sanitizing the public sector.
I am particularly delighted that the ICPC law under which you will operate is robust enough to assist the government to sanitize the public sector of corruption in service delivery, public procurement, diversion of public revenue, deliberate abuse of public funds, and so on. As I have noted in recent times, despite our anti-corruption drive, some agencies of government still divert or refuse to fully account for revenue generated.
He said those opposed to the fight against corruption berate the administration for its focus, determination and single-mindedness. The newly sworn-in chairman speaks on the Commission's preparedness for the task ahead.
I want to pledge on behalf of the Commission and the members, sir, that we'll do our best not to disappoint you or to disappoint the country.
The Senate confirmed the chairman and the members in October last year. Meanwhile, President Buhari received retired generals and former military administrators. Leader of the delegation, General Buba Marwa, says they represent 99.9% of their colleagues and are proud of President Buhari's achievements.
So the long and short of it is when you demonstrate what you say you will do, and you are from our own constituency, we must stand up and be counted. And therefore, the retired military officers today, with former military governors, the retired officers from the ranks of brigadier generals and their equivalents in the other services have come together today to tell him and to tell Nigerians that we are fully behind him in the elections next week, and we'll do whatever we can within the law to see that he's victorious in the election.
The delegation, comprising a vice admiral, 2 lieutenant generals and 15 major generals, among others, promised to support President Muhammadu Buhari in the February 16 elections. From the presidential villa in Abuja, Ibrahim Adra, Channels Television News.